So I want us to shift our attention to offenses against morality, which we call sexual offenses. Now, the background is that sexual offenses were previously governed under the Penal Code, but later it was replaced by the Sexual Offences Act number 3 of 2006. Now, what were the reasons for the reform? Now, the reason for the reform included, outdated definitions as far as sexual offenses are concerned. It included gender imbalance in protection as far as the sexual offenses are concerned. It included, lenient sentencing under the old law, and also the need for modern victim-centered kind of approach. Now, there are a number of sexual offenses that we are going to discuss, but the first sexual offense is what we call rape. And I want us to look at rape, critically. So what is rape? So rape is defined under Section 3 of the Sexual Offense Act, and rape is simply sexual penetration without consent. Now, the elements of rape, include the actus rea, and the actus rea include, number one, penetration, so that when it comes to penetration, the slightest penetration is sufficient to amount to rape. And this includes, the vagina, it includes the anus, it also includes, partial or full insertion. These can also qualify as rape. Now, the second actus rea element in rape is what we call lack of consent. If you look at the case of Naholi versus Republic of 1967, the facts of this particular case were that the accused was charged with rape involving sexual intercourse without consent. And the issue was, what are the essential elements of rape? And the rule is that rape requires proof of penetration, and it also requires proof of lack of consent. And the application of this particular case was that the court found that both elements must be proved beyond reasonable doubt. And so the conviction can only stand where both elements, and that is, lack of consent and penetration, are established. If you look at the case of Mwangi versus Republic of 1984, the facts of this particular case were that the accused challenged rape conviction due to lack of strong medical evidence. And the issue was whether penetration must be medically proven. And the rule is that penetration is the key element of rape. And the application of this case was that the court held that penetration can be proved through evidence other than medical findings. And so the conviction was actually upheld. If you look at the case of Andrew Apio Dunga versus Republic of 2010, the facts of this particular case were that the appeal challenged rape conviction due to absence of matching sperm evidence. And the issue was, is sperm matching necessary to prove rape? And the rule is that penetration alone is sufficient proof of rape. And so the application of this case was that the medical evidence of vaginal injury confirmed penetration. So the conviction was upheld. We also have the case of Muhammad versus Republic of 2011. And the facts of this particular case was that conviction challenged due to lack of medical evidence. And the issue was, can rape be proved without medical evidence? And the rule is that medical evidence is not mandatory if other evidence proves penetration. And the application was that the victim testimony was credible. And so the conviction was upheld. Now, let's look at the mens rea as far as rape is concerned. Now, the key requirement when it comes to the mens rea in rape is number one, intentional sexual penetration, and number two, knowledge of lack of consent or recklessness. Now, let's talk about consent briefly in relation to Section 42 of the Sexual Offences Act. So, consent means free agreement, it means capacity to decide, and it also means voluntary choice. If you look at the case of Republic versus Williams of 1923, the facts of this particular case were that a choir master deceived a girl into sexual intercourse, claiming it will improve her singing performance and ability. And the issue was, does consent obtained by fraud amount to valid consent? And the rule is that consent obtained by deception is not valid consent. And the application of this particular case was that the victim agreed under false belief. So the conviction for rape was upheld. If you look at the case of Republic versus Oyer of 1985, the facts of this particular case were that the accused were convicted of rape, and appeal questioned consent and intent. And the issue was what constitutes, the mens rea for rape. And the rule was that the mens rea is equivalent to intention to penetrate without consent or recklessness. And the application of this particular case was that the evidence showed resistance and lack of consent. And so the conviction was reinstated. We also have the case of Adamu Mulira versus Republic of 1953. And the facts of this particular case were that the accused argued victim consented. And the issue was, is consent essential in rape? And the rule was that lack of consent is fundamental to rape. And so the application of this case was that the court emphasized absence of consent at time of penetration. So it was confirmed consent, and it was said that confirmed consent is essential. We also have the case of Achoki versus Republic of 2000, and the facts of this particular case were that the appeal challenged rape conviction based on consent issues. And the issue was, is consent central to rape? And the rule is that consent is the core issue in rape. And the application of this particular case was that even apparent consent obtained fraudulently is invalid. And so the conviction was actually upheld. We also have the case of Naholi versus Republic of 1967. And the principle in this case was that even children require proof of lack of consent, but age may infer capacity. Age may infer incapacity. Now, I want us to look at child victims as far as rape is concerned. Now, the key rule when it comes to child victims is that child victims may not be capable of valid consent. In fact, age may itself prove lack of consent. If you look at the case of Eria Ngobi versus Republic of 1953, the facts of this particular case were that the accused raped a 7-year-old girl. And so the issue was, should rape or defilement be charged? And the rule was that children lack capacity to consent. And the application of this case was that the court accepted rape, that is the charge of rape, but recommended defilement as preferable. And so the conviction was actually upheld. In the case of Naholi versus Republic of 1967, the principle was that tender age may itself prove lack of consent. There is also the charge requirement as far as rape is concerned, and the legal requirement is that the charge must state, without consent and unlawful penetration. So it must have those two things, lack of consent and unlawful penetration. And we have the case of Stephen Odoro Uma versus Republic of 1999. And the facts of this particular case were that the accused challenged defective charge sheet. And the issue was, must charge include lack of consent? And the rule is that lack of consent is an essential ingredient. And the application of this particular case was that charge missing without consent was defective. And so the conviction was invalid. If you look at the case of Achoki versus Republic of 2000, the principle in this case was that omission of lack of consent makes charge incurably defective. We also have the idea of multiple offenders when it comes to rape. If you look at the case of Murunga versus Republic of 2008, the facts of this particular case were that several accused were charged jointly with rape. And so the issue was, can rape be committed jointly? And the rule is that rape is a personal physical act. And the application of this case was that each accused acted separately, and so each must be charged individually. If you look at the case of Kalu versus Republic of 2008, the facts of this particular case was that 3 men were charged jointly with rape. And the issue was, can multiple people commit rape simultaneously? And the rule is that penetration is an individual act. And the application of the case was that each accused, committed separate act, and so separate charges were actually required. Now, here is the key summary when it comes to rape. Remember, the essentials of rape include penetration, and we have said even the slightest penetration is sufficient, and it also includes, lack of consent. The mens rea of rape includes, intent to penetrate, and it also includes knowledge or recklessness as to lack of consent. So the key legal principle you must always remember is that consent must be free and voluntary, and also that fraud negates consent, and that children may lack capacity, and medical evidence is not mandatory when it comes to rape. Now, let's shift our attention to what is called spousal rape as far as rape is concerned. Now, the legal position, especially the common law position, is that a husband could not rape his wife. And the authority here is the case of Reg versus Mayers of 1872. And this is based on the doctrine of implied matrimonial consent. That is, the wife is deemed to have given perpetual consent upon marriage. However, there is a modern position as far as spousal rape is concerned, and the English courts have rejected marital immunity, so that spousal rape is now recognized in modern criminal law. However, Kenyan courts, hold a different position in that we don't have a direct Kenyan High Court or Supreme Court ruling on this matter yet. Be that as it may, Section 3 of the Sexual Offense Act defines rape broadly. In fact, the definition of rape is wide enough, to include rape within the confines of marriage. Therefore, marital immunity is not applicable in Kenya today. We also have the idea of corroboration when it comes to rape. And I want us to look at the meaning of corroboration. If you look at the case of Mukungu versus Republic of 2002, the facts of this particular case was that appeal involving conviction for sexual offense based mainly on complainant's testimony. So the issue was, what is the meaning of corroboration? And the rule is that corroboration is independent evidence supporting a material fact. And the application of this case was that corroboration strengthens complainant evidence in sexual offenses. So the conclusion was that corroboration amounts to supporting evidence confirming testimony. We also have the case of Katumba versus Uganda of 2000. And the facts of this particular case were that sexual offense conviction was challenged. And the issue was, what is the nature of corroboration? And the rule is that corroboration must be independent evidence linking the accused to the crime. And the application of this case was that it confirms both, commission of offense and identity of offender. So corroboration must implicate the accused directly. So what is the basis of corroboration when it comes to these particular cases involving sex? If you look at the case of Maina versus Republic of 1970, the facts of this particular case was that there was a conviction based on complainant's evidence in a sexual offense case. And the issue was whether it is safe to convict without corroboration. And the rule is that it is dangerous to convict predominantly on a complainant's testimony. And so the application of this case was that the sexual offenses are easily fabricated but difficult to disprove. And so courts should seek corroboration due to the risk of false allegation. So what is the principle of corroboration? If you look at the case of Musikira versus Republic of 1987, corroboration was stated to be essential in sexual offenses. In Njuguna, son of Wangu Rimu versus Republic of 1953, it was stated that corroboration is not a rule of law, but a rule of practice. In the case of Bernard Kebiba versus Republic, it was stated that confirmed corroboration is not mandatory in law. It is only mandatory in practice. But what is the current legal position as far as corroboration is concerned? Because we happen to have experienced, a constitutional shift as far as this issue of corroboration is concerned. If you look at the case of Mukungu versus Republic of 2002, the facts of this particular case was that the conviction based on complainant's testimony without corroboration. And the issue was whether corroboration is legally required. And the rule is that mandatory corroboration is discriminatory and unconstitutional. And so the application of this case is that it violates, equality provision, especially if you look at Section 82 of the old Constitution. So corroboration is not required as a rule of law. However, there is a warning rule. If you look at the case of Thuo versus Republic of 1988, the facts of this case were that the trial court convicted the accused on uncorroborated evidence. And so the issue was, is there a requirement of judicial warning? And the rule is that courts must warn itself of the danger of relying on uncorroborated evidence. And so the application of this particular case was that the conviction can still stand if court believes the complainant. And so failure to warn may invalidate conviction unless there is no miscarriage of justice. Now, what are the incidences of corroboration? If you look at the case of Republic versus Oyer of 1985, the facts of this particular case was that there was sexual offense case involving disputed consent. And the issue was what constitutes corroboration. And the rule is that behavior and circumstances may corroborate, the complainant. And so the application of this case was that resistance, injuries, escape, and accused conduct supported, the rape claim. And so circumstantial evidence, can actually amount to corroboration. In the case of Odhiambo and another versus Republic of 2005, the facts of this particular case was there was an appeal against conviction for sexual offense. And the issue was whether evidence was sufficient. And the rule is that strong identification and supporting medical evidence can corroborate. And so the application of this case was that lighting, duration, identification parade, and medical findings supported the claimant, so that the conviction was upheld on strong, consistent evidence. We also have the case of Waweru versus Republic of 1988, And the facts of this case were that the complainant was found distressed after alleged rape. And the issue was whether distress can amount to corroboration. And the rule is that victims' distressed condition and injuries may corroborate rape. And so the application of this particular case was that she was naked, injured, and she was in a terrified state, and that actually supported, the allegation. So the conclusion of this case was that distress and injuries can actually amount to valid corroboration. So here is the current position on corroboration. If you look at the case of Mukungu versus Republic of 2002, the facts of this particular case was that there was an appeal on conviction without corroboration. And the issue is constitutionality of corroboration requirement. And the rule is that mandatory corroboration is discriminatory. And so the application of this case is that it violates, equality rights under the Constitution. So the conclusion of this case was that corroboration is not required in sexual offenses. So what is the penalty for rape? The penalty for rape is minimum 10 years imprisonment and maximum life imprisonment. And that is according to the Sexual Offences Act. Now, I want us to shift our attention to attempted murder. Not attempted murder, but attempted rape. Now, attempt to unlawfully and intentionally cause penetration without consent amounts to attempted murder. I want to go that over again. Attempted murder is simply an attempt to unlawfully and intentionally cause penetration without consent. Now, what are the elements of attempted rape? Now, in the case of Crown versus Said Mshangama, the elements included a number of things. The elements included, intent to commit rape. It included, overt act towards execution, and it also included manifestation of intent. If you look at the case of Adamu Mulira versus Reginam, the facts of this case was that there was an attempted rape charge. And so the issue was what constitutes attempt. And the rule is that intent plus overt act despite resistance amounts to attempt. And the application of this case was that it must show effort to complete rape despite resistance. So that attempt, requires intention plus steps in execution. So the penalty for attempted rape is minimum 5 years imprisonment and maximum life imprisonment. We also have the idea of gang rape when it comes to rape. And the legal position is found in Section 10 of the Sexual Offences Act. And the essentials of gang rape, include, number one, rape committed jointly or in the company of others, and liability is based on common intention. So the penalty for gang rape is minimum 15 years imprisonment and maximum life imprisonment. The other sexual offense is what is known as sexual assault. So what is sexual assault? Sexual assault is the penetration of genitalia using body part or objects. So that sexual assault excludes medical or hygienic purposes. There are various elements of sexual assault. We have, the actus rea, that is the penetration without consent. And we also have the mens rea, that is the intention to penetrate. Now, the penalty for sexual assault is minimum 10 years imprisonment and up to life, especially where a child is actually involved. The next sexual offense is indecent act. Now, what is indecent act? Indecent act means sexual contact without penetration. Now, indecent act includes, exposure of sexual material, And the offense are captured in section 6, where you have compelled indecent act. Section 7, where you have indecent act in the presence of others. Section 11 and 12, where you have indecent act with a child or an adult. So the penalty for indecent act is 5 to 10 years, depending on the offense. If you look at the case of Thumi versus Republic of 1984, the facts of this particular case were that the accused argued that the child consented. And the issue was whether consent is a defense. And the rule is that child consent is not a defense to indecent assault. So the application of this particular case is that the law protects minors, and it protects minors absolutely. So consent of a child is actually irrelevant. So here is a brief summary of what we have covered so far. Remember, we've talked about spousal rape, and we have said it is now recognized under statutory interpretation. We have also talked about corroboration, which was historically required, but now it is not mandatory, it is only cautionary. And sexual offenses law emphasizes, consent, it emphasizes credibility, and it also emphasizes, statutory definition over common law doctrines. Now, the next sexual offense is called incest. Now, what is incest? You say incest is defined under section 20, 21, and 22 of the Sexual Offense Act. Now, incest prohibits sexual intercourse between persons within prohibited degrees of family relationship. Now, the prohibited relationships include, the male offender, this is covered under section 20, having, sexual intercourse with the daughter, the mother, the sister, the grandmother, the granddaughter, the aunt, or the niece. We also have a female offender covered under section 21, that is having sexual intercourse with son, father, brother, grandfather, grandson, uncle, or nephew. We also have section 22 of the Sexual Offences Act, and it also includes, half siblings, it includes adoptive relatives, and it includes, first degree uncles or aunties. Now, it is interesting to note that cousins are not included. Now, the rationale for prohibiting incest is that incest does a number of things. Number one, incest protects family integrity and morality. Secondly, incest prevents genetic disorders from inbreeding, and incest also protects minors from intrafamily sexual exploitation. Now, the actus reus of incest is normally sexual penetration between prohibited relatives. So, for the mens rea of incest, we have intentional sexual intercourse and knowledge of familial relationship. Now, remember, consent is not a defense when it comes to incest. And the penalty for incest is usually twofold. Number one, we have general incest, and the penalty is 10 years or even more imprisonment. And we also have incest with a female child under the age of 18, and the penalty for this one is usually life imprisonment. If you look at the case of Barugahara versus Uganda of 1969, the facts of this particular case were that the accused convicted of incest with his daughter born out of wedlock. And so the issue was whether illegitimacy affects incest liability. And the rule is that incest applies regardless of legitimacy of birth. And so the application of this case was that genetic relationship is sufficient. So the conclusion is that incest is committed even outside lawful marriage. The next sexual offense is sexual harassment and exploitation. Now, sexual harassment is covered under section 23, and it is defined as persistent, unwelcomed sexual advances. by, you see, persons in authority, that is, employer or a public officer. Now, the elements of sexual harassment include number one, knowledge that advances are unwelcome, and then the link between submission, stroke rejection, and employment decision, and also the creation of a hostile working environment. Now, the penalty for sexual harassment is usually 3 years imprisonment or a fine or both. There is also sexual exploitation in authority as covered in Section 24. And the protected persons here are prisoners and inmates. They are detainees. The protected persons are patients. The protected persons are students and wards under custody. Now, the offense here is the abuse of position to induce or seduce sexual acts. Now, the general mens rea of sexual exploitation in authority includes, number one, knowledge of authority, relationship, and also the intent to exploit. Now, the penalty for sexual exploitation in authority is 10 years or even more imprisonment. Now, the key rule according to Section 25 of the Sexual Offence Act is that there is no offence if prior consensual sexual relationship existed. However, the burden of proof lies on the accused person. The other sexual offense is transmission of HIV and STDs, and this is covered under Section 26 of the Sexual Offence Act. Now, the actus rea for transmission of HIV and STD is the doing or permitting acts that cause infection. And here, sexual or non-sexual transmission are actually included. Now, the mens rea for transmission of HIV and STDs include, number one, knowledge of infection risk, and number two, intent to transmit or recklessness. Now, the penalty for transmission of HIV and STDs is usually 15 years imprisonment or even up to life. Now, the key rule when it comes to transmission of HIV and STDs is that marriage is not a defense. Knowledge of infection is very crucial. Now, let's look at the other related offenses to sexual offenses. We have the first one, which is unnatural offenses. And this is found in Section 162 of the Penal Code. And this is simply, carnal knowledge against the order of nature. And it includes, consensual and natural acts. It includes bestiality and permitting such acts, so that the penalty for unnatural acts is up to 14 years imprisonment. We also have abortion offenses, which are found in Section 158, and it involves, procurement of abortion. And this is attempting abortion using drugs or even force. And the penalty is 14 years imprisonment. Section 159 covers self-abortion, and this is where, a woman procures her own miscarriage, and the penalty is 7 years imprisonment. Section 160 deals with supplying instrument, that is supplying abortion tools knowingly, and the penalty is 3 years imprisonment. Another offense related to sexual offenses is conspiracy to defile, and this is found in Section 157 of the Penal Code. And conspiracy to defile is conspiracy to induce sexual intercourse by fraud or even by force, and the penalty is up to 3 years imprisonment. We also have other sexual offenses. If you look at Section 27, it talks about, drugging for sexual activity. That is administering substances to stupefy the victim. And this also enables sexual exploitation. Section 28 deals with distribution of drugs, that is supplying substances for sexual coercion. Section 29 deals with cultural / religious sexual coercion, and this simply means, practices forcing sexual acts which are criminal. Section 30 deals with the duty to disclose sexual conviction, where one must disclose, prior convictions when seeking, authority jobs, so that failure to do so is a criminal offense. So the summary of what we've covered so far is that incest is the strict prohibition based on family ties and also knowledge. And sexual harassment is the abuse of authority in a workplace or public office. And HIV transmission is strict liability with high penalties. Now, remember, the related offenses aim to protect children, they aim to prevent exploitation of power, and they also aim to regulate sexual morality in public places. So that is all I have as far as sexual offenses are concerned. If it is your first time here, make sure to subscribe and to follow this channel for more legal lessons.